Hello, good afternoon, everyone. AmerBON is back again. Today we have three speakers. First is AmerBON, and then my co-chair and Joshua Tay. Today our topic is about employment issues. As everyone knows, the employment issues has been really troubling our employees ever since the COVID-19 and the MCO began in March, and a lot of people have been retrenched or terminated, or you have your salary cut, but you might not know who to speak to, and you might have a lot of legal issues that you need addressed. So today our speakers would address all these problems, and so without further ado, let's welcome Mike to begin the session. Mike, please.
Hi everyone. Okay, so thank you. As she has mentioned, I will be addressing some employment issues that has arisen as a result of this COVID-19 pandemic again. We've addressed it in our previous sessions, but I think this session will be more focused. All right. So, but I want to first draw you to an article that was just reported recently. Let me show screen. So let me show the screen. Yeah, hold on. All right. All right, this article. If you can see, it was reported in the Malay Mail that SOCSO reported job losses in Malaysia increased by 42% in Q1 due to COVID-19. So as you see here, it says due to COVID-19 pandemic, job losses in the country has increased by 42% year on year for this first quarter, according to SOCSO. All right. Then it goes on to say it has impacted many businesses with an experience to drop in demand of 37% or being unable to operate as usual at 42%. So then this part is also important. This trend is only expected to accelerate from April 2020 onwards, with job losses increasing by 50% to 20% year on year with each subsequent quarter 2020. So it means that what has been projected is that there will be more, that it is expected that there will be more job losses coming ahead. But and also it says that the employment rate is forecasted to hit 4% in 2020 compared to the 3.2% during the earlier Asian financial crisis. Okay, so yeah, so these are worrying figures, but we are here to discuss on how on what can be done. What do you call this when you are faced with this kind of situation? So what has happened is that for this chit chat, the first part I'll be looking at employees' rights and their protection during under the Employment Act when a person is being terminated, right? So it includes what benefits they're entitled to also when they are being sort of like retrenched. Okay, so for the first part, I think it's important to state out that the Employment Act does not apply to everyone. It applies to a certain category of workers. All right, it applies to employees who are employed under a contract of service, whether it is oral or in writing in Peninsular Malaysia and also federal territories of Labuan. Sabah and Sarawak, they have their own Labour Ordinance, which will not be part of this chit chat discussion. All right. So first category, it covers the employment covers those with a monthly salary that is not above 2,000 ringgit. Okay, so it's a social legislation aimed to protect those at the lower income bracket by looking at this category. Okay, so then the second category, also those who are engaged as manual laborers, including the supervisors or those who oversee the work of the manual labor, regardless of how much they're earning. Okay, so those who are engaged in the operation and maintenance of mechanically propelled vehicles, also known as also in simple terms, motor vehicles. Okay, so this is also regardless how much they're earning. Those who are engaged in any capacity on a vessel registered in Malaysia, subject to certain qualification conditions. Okay, these are provided under the Employment Act. Domestic servants also are covered, but I like to point out that some provisions of the Employment Act will not apply to those engaged in any capacity on a vessel, okay, and domestic servants. So there are certain Employment Act provisions that don't apply to these people. But generally, the provisions that the general principles under the Employment Act would be applicable. Okay, so yeah, as I mentioned earlier, the Employment Act does not cover Sabah and Sarawak, but then the principles also would be the same. Okay, would be similar. All right. So under the Employment Act, the employment contract can be terminated by either the employer or an employee. All right. For an employer to terminate the contract of an employee, there must first be just cause and excuse. There must be a proper reason for him to terminate the contract. Okay. So, and as one decides to terminate contract, okay, either the employer or the employee, there has to be notice given to the other party. All right. So the employer must give notice to the employee. The employer must give notice to the employee. The vice versa. Okay, and it has to be done in writing. Okay. So then the question comes as to how long before must you give the notice? So the notice period for termination depends on what the contract says. So you always go back to the employment contract. Okay. Some can say in the employment contract it can be 1 month. Some can say 2 months. All right. So, but the Employment Act provides that if the contract does not say what your notice period is, okay, then it provides for a range of notice period depending on the years of service. Okay. So the notice in writing for an employee with less than must be given to an employee with the notice in writing that has to be given for an employee with less than 2 years of service shall not be less than 4 weeks. Okay. So, and for employee with more than 2 years but less than 5 years of service shall not be less than 6 weeks. For an employee with more than 5 years of service shall not be less than 8 weeks. So the notice period is increased as your years of service with the longer years of service. Okay, so that is these are the notice periods which are provided under the Employment Act in the event if the contract the contract of employment does not provide for a notice period. Okay, so this notice period also covers a situation where you are terminated on grounds where you are redundant. So when there's retrenchment basically, so if there's a retrenchment, then this notice period would also apply. You have to look at the contract first, see what notice period says there. If not, then you look at the notice period under the Employment Act, as I mentioned earlier. Okay, I'll deal with retrenchment slightly more specific later. All right. So alternatively, if an employer does not want the employee to serve the full notice period, means he wants to cut short the notice period, or he wants to immediately terminate the employment, okay, of the employee, the employer needs to pay the same wages one would have earned during the notice period. Okay, so this is the same also applies to employees. If you as an employee do not want to go through the period, the notice period, the employee has to compensate, all right, for that particular period of time where for the wages that he or she would have earned during the notice period. So for example, okay, if you are given a shorter notice period than prescribed under the contract, okay, or the employment contract or the Employment Act, you are entitled for wages for the remaining period of time. Okay, so if you are shortchanged, then you are entitled for that period of time where you are supposed you are entitled to that is provided basically under, you can look at section 12, section 13 of the Employment Act. They is spelled out quite in quite detailed there. All right. So yeah, so this applies to those categories of employees which I've mentioned earlier. All right. So then, specifically, when you are being retrenched by an employer, uh, and you have worked for the employer for at least 12 months, okay, under the Employment Termination and Lay-Off Benefits regulation, you're entitled to layoff benefits. Okay. So the benefits are, for 1 to 2 years of service, you are entitled to 10 days wages for each year of service. Okay. For more than 2 but less than 5 years of service, 15 days wages for each year of service. More than 5 years of service, 20 days wages for each year of service. Okay. So you can look at the Employment Termination and Layoff Benefit regulations regarding this. Okay, so this is basically your right, okay, as an employee when you're being terminated, and the benefits that you're entitled to in the event you are terminated or being retrenched. Okay, so basically that's in gist what you need to know when faced with a termination in these difficult times. All right, so the second part which I'll discuss is the different scenarios, as I mentioned. We have come across a few types of scenarios over the course of the past few weeks, right? So the first one, the first scenario is on retrenchment. Okay, so I received news that Michael, my company, is suffering a lot of losses. They are going to let me go. They're going to let all of us go. Or recently, if you've seen the news reports, Genting has let go a substantial amount of their employment workforce, okay, to reduce losses. Okay, so now then people ask me whether that can be done. So I think I just want to make it clear that employers under the law are entitled to determine the strength of their staff, which it considers necessary for them to carry out their business for more efficient operations. Okay, so and retrenchment is also justified. Courts have found that retrenchment is justified that when business is faced with severe losses and they have to cut costs in order to survive and to be more efficient. So the industrial court, has given awards and it has been recognized by the High Court and the appellate courts that retrenchment is justified, but the condition is that the retrenchment must be genuine. Okay, there must be a genuine reason for the company to retrench. Okay, like I mentioned just now, it's justified when the business faces severe losses and they have no choice but to cut down on costs. So that's a genuine reason. So, but how that reason is being proved in court is another issue which I will not address today. So the courts will have to go to court and industrial court, prove their financial statements and all that. Okay. So about principle, yeah, those are considered genuine reasons for retrenchment. But the retrenchment is considered not genuine if it is motivated by bad faith and a desire to victimize or harass an employee. For example, if an employer does not like an employee but purposely comes up with a reason to say that, oh, our finances are bad, and specifically targets that person and retrenches that person, say that that we don't need you in position, just by giving the reasons of redundancy when he is the only person being retrenched at a point of time. And yeah, so that those are some reasons that could possibly fall within the category of bad faith, or it is a desire to victimize that employee. Okay, so if there is then if it is if the retrenchment is motivated by bad faith and all that, so then there is a potential case against the employer that the termination was without just cause and excuse. So as I mentioned just now, the scenarios and the factors differ. So it is really on a case by case basis, and not every facts are the same. So it really depends on what has happened during the course of prior to the retrenchment, and also what the employer does post retrenchment. So all those facts are very important. So if you are faced in this situation, I think it is very important to record down what has been done, or as an employee, record down what has been done before your termination and also after your termination. So these records are very important to help lawyers determine and frame, and to find out to see whether there was actually a genuine retrenchment or not. Okay, so yeah, that's retrenchment. The other issue that we have seen over the course of past few months, like even in our earlier chats, we said that we found that there were employers who were proposing to employees to take a salary cut, meaning take a 50% cut or take a 30% cut if you are below a certain, if you are above a certain pay grade, you take a certain 20% cut, something like that. Okay, or you defer your salary for the next few months, something and stuff like that. Okay, so as I mentioned, this your employment is basically premised on your employment contract, on how you have what are the terms you have been engaged with your employer. So when there is sort of like this request to reduce your salary and all that, that would amount to a variation of the contract. For a variation of the contract, what is necessary is that both parties, employer and employee, must agree to that variation. Okay, so if for example, if the proposal is being made out to you and you do not agree to that proposal, then what happens? Are you forced to accept the thing? No, there is still a remedy, but then a remedy which is very obviously the first remedy which I would recommend, which I've recommended, is to go and talk to your employer, to ask the employer to reconsider his proposal until an adequate solution is arrived at. So both parties agree to, probably if both parties understand the difficulties being faced by the company, they can say, all right, the employee agrees to a slightly lesser pay cut. So then both parties agree, then there's not an issue, and it has to be in writing. All right. So but if push comes to shove, there is no way that you can there's no way that you can come to an agreement anymore, and the employer imposes it on you unilaterally, means he imposes it on you without your consent at all. Okay, say the next month, I don't care, you are going to get a salary reduction. So what options do you have? You can cite constructive dismissal. So what is constructive dismissal? We have discussed this in our earlier sessions. Constructive dismissal is where an employer, you as an employer, you are terminating your employment contract due to the breach of the contract committed by employer, because the breach in this case would be the employer forcing that change in that contract to get a lower salary. So but then to satisfy constructive dismissal and all that, you need to prove, the elements are that you need to prove that there's a breach of contract by the employer. Okay, so secondly, the breach must be so important to justify you from resigning resigning from your position. And when you leave, you must leave in response to that breach, not in response to that breach of contract, by the employer, not unilaterally imposing the salary reduction on you. Cannot be for some other unconnected reasons. And the employee must leave immediately. So if you decide to cite constructive dismissal and say that, okay, I'm being constructively dismissed, you must leave immediately. You cannot wait for a long period of time. And then, because if you wait for a long period of time, it'll be deemed that you are, you acknowledge that dismissal and that variation in your contract. So yeah, so then how do you go about this? So if practically speaking, if because I'm focused on this session is focused on those who are covered under the Employment Act. So those who are earning below 5,000 ringgit, all right, you have the option of number one, going to the Department of Labour and making a complaint. Okay, making a complaint to Director General of Labour. Director General of Labour would then investigate the issue, call parties, and and look into all, investigate the case, and then he can order the employer to pay you the balance of salary that you actually, what do you call it, you the balance of salary that you are entitled to. Okay, so that can be done immediately while you're still in employment and all that. So while you're still in employment or immediately after you're being retrenched and all, and yeah, so that can be done. So then, alternatively, you can also go to the Department of Industrial Relations to file if you're being terminated, or if you have been terminated, or if you have been uh what do you call, if you've been terminated or constructively, or if you have cited constructive dismissal, you can go to the Department of Labor, Department of Industrial Relations, and make a representation. All right. So, and then the Director of Industrial Relations can investigate your case and then call for reconciliation process. So reconciliation process would include the employer, the employee. They'll come together and they'll discuss to find a viable solution. And if it's unsuccessful, then the minister may refer it to the industrial court. So at the industrial court, then your case will be litigated lah in the industrial court. So yeah, so that and as a result of that, as a result of the industrial court proceedings, if you're successful, you'll be able to get back wages, or you can be reinstated, or you can get wages in replacement for reinstatement. Okay, so these are the three options that you are entitled to at the industrial court. So yeah, so basically that's in the gist of what you can do during this during this MCO period when you are faced with issues of termination or reduction in salary. Okay, so I hope that helps. But if you have any questions, please feel free to ask at the comment section. Thank you.
Thank you very much, Mike. I hope the information just given by Mike can help everyone. Next up, can I invite Joshua to also give us a few words on and sharing on what he thinks about the employment issue?
Hi. Actually, I just wanted to share about the situation relating to law firms and lawyers. We talk about, I think Mike, in fact, Mike, Sinu, and Edmund has been talking about employment. I think even from the start of this series, and I think there's a lot of people who has asked over social media about this issue. But I think as lawyers, we have seen that I think the COVID pandemic has negatively affected businesses. We've seen, or it was reported that there are many smaller firms had closed shop as they could. It wasn't sustainable to continue business, and we also see many big firms who usually prior to the pandemic has been were always on top of the applicants list of top choices for employment, as you know they offer huge salary and I think bonuses. But then during and after a few months of this MCO, we have heard or we have obtained information that there's a lot of these big firms were cutting salaries from their lawyers, some up to 40%. And of course, even partners had to recontribute their capital, put in capital into the firm. It's interesting, I think, to ask Edmund what does he think. How long would this situation last? Because I think previously it was just the salary cut was justified, because lawyers were not required to go in office, and they were not required to work on site. So now that the government has allowed, I think, lawyers to go back to office and work as usual, do you think these salary cuts is justified, and how long do you think this problem will persist?
Okay, Joshua.
Oh, you're supposed to answer the question.
There's no question, so I think I'd rather ask a question.
Let's talk about the law firms, but in general about other companies. And I think one question that I want to ask, and I think a lot of people ask Mike, is how do you expect the employees who are in a weaker bargaining position without a union or without a collective in a private company to be able to say no to a company, whether it's a law firm or not a law firm, who wants to vary the contract and cut salary up to 50%. I heard there are some firms that cut up to 80%. There are some firms even cut up to 99% and then say that you take it or leave it, because the market is so bad. They know that the employee would prefer to stay on even though there's a massive salary cut, as the employee cannot find a job quickly, the next few weeks after the lockdown is lifted. So that is my question. How do you expect those employees to, and we have so many complaints that have come in, how do you expect those employees, one without a union or even without a union in a corporation, how do you expect employees to say no to these proposed cuts? And then the employers will say, there's this agreement, because the employees just cannot say no. And two of the reasons would be, one, they cannot find another job somewhere else, and the employer knows that. And two, the employee just doesn't, even though they know their rights, they just say, you know what, I cannot do anything. So what's the solution to that, Mike?
Mike, I think you are muted.
So basically, I think when employees are being asked, right, to take a salary cut, to vary their contract, it doesn't affect only just one person. So it affects, I think, a whole group of employees. And I think what I've advised those who have asked me was that they should actually, although there is no union for them, but they can always go in groups to approach their employers. That's one of the few practical solutions, is to go together and see their employers, and also to push their employers as a group rather than an individual alone. Because if you go individually alone, then you will obviously have a lesser bargaining power. So that is why I've suggested that they don't go to their bosses to discuss about the reduction or variation in their contract alone. It has to be done in a group, a substantial amount of people, so that
But what if it's a small firm? You only have 2 people in a firm or 3 people in a firm. Are you asking for industrial disharmony? You're asking to mobilize. Are you asking the workers to mobilize in their workplaces? And in private companies, there are no unions, right? Office staff may not be part of a union.
No, I think it's not just one company, but then I think, like you see, you can't just look at it from microscopic company by company basis, but if you can look at it from a bigger picture, where all these people under the same category from different companies can come together, and they can push for the same thing, all right, same vision, to not have their salary deducted so much, then probably it can work. And you have seen, I think, campaigns being run on social media, you know, on this kind of issues, and they have been successful. So I don't see it as an issue, or to look at it just specifically as a clerk working in a company, but then like you have to look at the person has to look at it more holistically, like in terms of everyone else who are in the same position as them. Sure, because it's not just them facing the problem. There's so many other people. So then I think I'm supporting that idea that everyone who are in the same category of people, although different companies and although they do not have unions, to stand up, I think, to voice their concern, and also make a report to the Department of Labour or the Department of Industrial Relations regarding their issues, or see a lawyer. See, these are the few options.
That's idealistic. And of course, that's good if it can happen. But even the young lawyers in law firms, we heard and we receive information from so many young lawyers about what's happening in law firms. If you can't even expect the lawyers themselves to get cut, who get cut on their salary and on their bonus and all of that, there's so many different ways these law firms have tried to vary the contracts, right? If you can't expect these young lawyers to stand up for themselves and do it for themselves, and the bar council to do anything on it, then how do you expect the even more lowly paid workers to be able to mobilize that way? Isn't that the workplace reality that we are facing? And then the question also becomes, if employers receive pre-Hatin benefits, yet the employees are retrenched or salary cuts are provided for, isn't that also amounting to a dismissal or a breach of the terms of receiving that compensation? Because one of the terms are that you cannot retrench or you cannot cut their salaries. So that is another question that has come in, right? So one, yeah, it's idealistic. How do young lawyers even want to fight against that kind of oppression by law firms?
Yeah. Actually, I last year, I think someone complained to me and shared about his experience. He was one of the senior LAs in the firm, and he was they basically, the LAs had a meeting, and they were complaining to him about, you know, their working conditions, and he brought this up to the partners, and basically what happened was that nothing got solved, but his bonus got docked. So you see, I think Mike, in those kind of cases, I know ideally you said that, you know, they should go in groups, but then as I think employers, or you know, big corporations or big firms, sometimes they use these other sort of tactics to silence their employees. So in those kind of cases, then what do you think should practically be, you know, the solution for these young lawyers? What should they do?
Well, I think because you see, you mentioned bonus, right? Bonus, there is no term that, you know, you can give bonuses for, there's a certain limit or amount that you have to give contractually to a person. But then, because bonuses are determined by the employers based on your performance, it's discretionary. So because it's discretionary, so it's very hard to argue that, you know, you have been targeted, unless that you have been targeted or you've been victimized, you know, as a result of what you have done against the employers. You need to show that that proof before you can do that. If not, in terms, like, based on what you tell me, bonuses are discretionary. So if he received a lower bonus, maybe there may be other factors. So I don't know. I can't really say how, but I understand that could be a possible mechanism for employers to what do you call this, to attack or sort of like victimize these kind of people who go against employers.
But Mike, I think relevant to that question is, if you are saying this, right, is it time for even lawyers, let's talk about profession, even for lawyers or young lawyers, to set up some form of group or trade union type collective. Under Mahathir, the trade unions and the laws to curtail the right to strike, right to freedom of association have all been put in place, that now there's no power anymore. There's no power for workers to mobilize, to come together. And this hurts actually more of the low-wage workers. And we can see from the lawyers in the profession, if they themselves are not going to speak out and stand up, and like Joshua gave an example just now, then it's going to be really oppressive or difficult. So maybe the mobilization is important. That's one, to create some sort of, even NGOs, whether we need a trade union for CSO NGO workers. Number two, the other one is, the other question really is, why when employers are going to give salary cuts like this, and you say there's a genuineness that requires to be scrutinized by the court, why can't these employers who are already giving the cuts or wanting to discuss variation actually show their accounts to all their staff, for example, or their bank statements, to prove that there is no cash flow? Because, as you said, sometimes this COVID example is given to terminate employees who may not be the ones that they want to be kept, the employers want to keep. So even this genuineness of retrenchment or genuineness of salary cuts, the bigger question for the workers, is it to make sure that the pockets are still lined of the shareholders, or is it really genuine that these cuts are necessary? Big law firms or big corporations should have savings at least to rough it out for 2-3 months. But it appears that they immediately take advantage of the COVID reason to offer these variations. So these are questions that have come. What do you think, Mike? I think a lot of people, this segment was crafted because a lot of people are asking these questions.
Yeah, I agree. I mean, in terms of the legal industry, I agree that we should be able to unionize lah. The lower rung lawyers should be allowed to unionize, and there have also been talks by young lawyers that there should be a minimum wage for pupils to begin with, minimum wage for pupils, and also a minimum wage for young lawyers who are of certain years of practice. So I think, and also there should also be protection. I mean, there should also be mechanisms to support younger lawyers, which I think may be lacking in our whole legal statute. The laws protecting lawyers. So because, as you said, they are the most vulnerable at the bottom there. So yeah, I agree that the proposals you've made is ways that we can push for more industrial harmony between employers and lawyers and employees in the legal industry, and also make it a better working place for lawyers. So yeah, that's what I think.
Thank you, Mike. We have a question in the comment box, which I think a lot of people would be asking also, because not many people are still working from home, and when they are being terminated, the employer would just send by emails or letters, and that means that you are terminated. So what's your view on this? Is termination by email acceptable?
The Employment Act and the Employment Act and also the Industrial Relations Act do not provide for a method of how termination can be done. So it can be done. it can be done to a certain extent orally, but best is also to have it in writing. So now the mode of communicating the termination is best that is written. Okay, so yeah, it can be by email. So, but as long as that person, the employee receives as long as the employee receives notice of that termination, or the employer receives notice of that termination, because the notice is important. And yeah, so that's my answer. It is possible. It is acceptable.
Mike, you just filed one representation recently, right? I think people want to know. I also want to know, how do you file the representation if they don't? Do they have to physically go there to the office or?
Okay. So yeah, what has happened is recently we have just filed the representation under Section 20 on the Industrial Act for to the Director General of Industrial Relations for unfair termination. So what we did was, because of MCO, we were not allowed. I mean, client was not allowed to travel, obviously. So because of that, the Department of Industrial Relations allowed for submissions to be sent by email. So there's a form that you have to download online, and you have to fill in the form. Once you fill in the form, you don't have to go to the Department of Industrial Relations physically, but you can just email the form there, and then they will send an email back to say that, okay, we have accepted your representation, and we are going to set the date for the reconciliation meeting on this specific date at this location, blah blah blah. So that is basically allowed by the Department of Industrial Relations now. So yeah, but now with a more relaxed movement control order, if you are able to go there by if you're able to go there physically, then yeah, by all means go there physically. But when you go there physically to fill up the form, make sure you bring with you your employment contract, your termination, your termination letter, and also a photocopy of your IC or passport. So yeah, and also reconciliation. I was informed the reconciliation for the representation that we have made recently has not come up yet. So, but we were informed that it could be done online. So, but then we have not worked out the mechanics on how the reconciliation can be done. So, but yeah, so that's about it. So the reconciliation process, I mean, usually the Department of Industrial Relations will get back to you within 1 to 2 weeks, 2 to 3 weeks, and then there may be a few reconciliation process. So after that, so the one that we received, the reconciliation proceeding is set in July. So that has been about 3 weeks. That's been a month since we filed the representation. But it also it depends on how long how fast the department processes that thing and how many representations they've been receiving. Okay, so it depends on the volume of cases also. But remember that you need to file the representation within 60 days from your termination. Okay, that's the time period that you need to file. Yeah, so yeah, that's it. Then after that, there is no set time limit as to how long the minister is to send your case to the industrial court if the reconciliation process is unsuccessful. But usually there will be a letter which comes to say that you've been sent to the industrial court. The industrial court within their system will manage it and send you a date as to when is your first mention and all that. So yeah.
Thank you very much for the information, Mike. So if anyone has been terminated and you want to be reinstated, remember to file your application to the nearest Department of Industrial Relations that's nearest to your previous place of employment. We have another question. It is, if after working for 1 year and still under probation and have been receiving statutory EPF and SOCSO contributions, but out of the blue he has been terminated, will there be any compensation that will be available to him? Mike or Joshua will be able to take this.
Okay. I think I'll be able to address this. Okay, I'm not really sure what kind of compensation you're asking here, but then, as I mentioned earlier, you can, being still under probation, and being dismissed after that, there has to be just cause and excuse for the termination. So yeah, you are still allowed to file a complaint, representation to the Department of Industrial Relations. So then, as I mentioned earlier, when you go to the Department of Industrial Relations, go to Industrial Court, and then the Industrial Court, if it rules in your favor, then the court can give you back wages, and also can also award you back wages and also or reinstatement or back wages in lieu of reinstatement.
Thank you, Mike. We just have another question from the comment box. It's from Sivaranjan. The question is, if an employee has been ordered to be transferred to another department while the employer is under PKP and working from home, and he's asked to report to the new section, employee disagrees with transfer, management terminates under section 15, subsection 2 of the Employment Act for failing to turn up for work in new section. He's asking if you have any views, maybe Edmund or Mike. Do you have any opinion on this?
Okay, I think I can take this. You need to go back to the employment contract. You need to see whether the employment contract allows for the employer to transfer this person between departments or between services. Okay, so you need to first look at that first. If there's such a clause, then the employee cannot then complain and say that, I do not like that position. So you still have to go back to the contract first. But just say if the contract does not allow, so as I mentioned, if the contract allows for such transfer, then it'll be difficult to argue that, for him to disagree with that transfer, for the employee to disagree with that transfer. But if the contract is clear as to what he is supposed to do, what are the services he has to provide, specific, and there's no clause saying that he is to be transferred and all that, then there will probably be a case for against the employer for unjust termination, because and also the employee can also cite constructive dismissal in that situation. So you have to look at the contract first to see how it's being framed.
The job description has to be looked at in terms of what is required under the new transfer, under the new department.
Yeah,
isn't it?
That also, yes.
But if the job description is the same and while the department may be different, then it may be harder to argue. So it depends on the facts of the case. However, I think if there is PKP and the order was to work from home, then I don't think the employee can be expected to turn up for work during the control order, unless they fall under those exceptions of the order.
Thank you very much, Edmund and Mike. As the employment issues are still, it's going to be not going to end in the near future, and retrenchment, salary cuts are going to still last for a while, and it will be very difficult for people to actually leave their jobs and to look for a new job. So,
but in the law firm industry, I think the question becomes now, moving ahead, whether law firms, in the way compensation packages are provided for, are they really sustainable? So I do not know whether you all have views, because I think some of you know well, people know about our views as employers. And the law firm industry or the legal industry, the services industry actually has a very different model, because services are difficult to price. You can price a bottle of Coca-Cola, but how, because you know how much ingredients are put in, transport costs. How do you price the brain of Joshua Tay who writes a legal opinion? Or how do you price your efforts in advising a client after writing 10 hours of a submission and then going to court, right? If you do that, Mike. So the services industry, I think all over the world is also hit. But the question becomes, and I'll be interested, I think, to hear if you all have any views, how you see with your friends who are younger than us, younger than me, what do they think about it in the current Malaysian legal industry scenario, the landscape? Because like Joshua said, or Mike, you said, there are some law firms who come out and say, we're going to offer you crazy sums of money. When I started at Chit & Company, I recall there were pupillage, I think the highest was 1,000 ringgit a month. That was in 1996, 1997. And I think there were only three or four law firms that were paying so high. Now it looks like pupils get paid so much higher as well, although they really are not properly trained by our universities. So what is the word on the ground before we end? I think that's something that a lot of people want to hear about as well.
I think many different firms are offering different amount of salaries, and the one from a pupil's perspective, as what I heard from my friend and what I think is going on, is they have received pay cut, and it can go up to 50% or 80%. But then, you know, as a pupil, first of all, it's not easy to find a job in the first place. And after you got the job and then you got the salary cut, even though it's reduced to an unrealistic amount, but we still have to stay there. So that's just from the pupil's perspective, but I'm not sure if you guys have anything to comment on it.
Yeah, I think the idea that, you know, an employee, including a lawyer, to be remunerated proportionally to his work, right, or capabilities is quite an attractive idea lah. It's just that I think it's quite difficult to sort of implement that kind of system, because number one, I think of course the employee themselves may value their own work differently from the employer, right? So maybe the employer thinks that, you know, this employee is worth paying 10,000 a month, but then the employee may think he's worth 15 or 20,000. But in actual fact, maybe the employee could not perform or could not achieve the target set, or could not come up to the expectations of the employer. So I don't know. I think probably the best system is still the system which we are currently using in AmerBON, which is each lawyer, including pupils, interns, partners, and senior lawyers, they get a percentage of the fees, of course proportionate to the amount of work they put in lah. So I think that's my view. I don't see personally I don't see any other alternatives lah to strike a balance between the interests of the employer and the employee.
No, the reason why I asked is because everybody complains about it in the corridors of the court canteen, and young lawyers keep complaining for many years. That's why when I was chairing the committee many years ago, we did a working condition survey. But then they don't want to talk about it publicly. They don't want to, interfere or irritate their bosses. But sometimes you see in the press about workers, lawyers complaining that they work too hard and not paid fairly, and then now they get cut as well, but they cannot do anything. But we only see anecdotal WhatsApps evidence that goes around about the law firm cuts. So it's good to at least talk about it more in the open and find ways to move forward rather than just leave it to the law firms to decide on the compensation. So I don't know, Mike, you heard about anything regarding this among your circle?
Those in my circle, most of them they have fixed salaries. So every time, when we explain to them about our remuneration system at our firm, I think they are attracted to that. Like even like what Joshua said, I have not come across an alternative to our structure lah. So basically is whether you're paid fixed salary or remunerated like how we are how we are in our firm. But I think there are some firms which vary their bonuses, so they give a bigger lump sum bonus at first. So they give a every 3 months bonus or something like that. So there is like, and instead of waiting for bonus towards the end of the year, or towards the end of towards the end of the year, then they break down the bonus in 3 months depending on the quarters. So that's one maybe slightly different variation, but they are still being paid fixed salary. So it's just that their bonus varies, but it's still a fixed salary lah. So the only difference is, I think, is the two alternatives I see now is the fixed salary or our system of remuneration.
Right. Thank you, Mike. Yeah, I think one of the benefits of having a percentage-based remuneration system is that you would be motivated, and there would be an incentive for you to work harder and to work better on your files, and that's one of the benefits of it. I think it's already 1 o'clock, so we have one last, maybe we can address one last question from the chat box. It's from Rahu. For termination, is a written or email warning letter mandatory? Perhaps Mike can answer this.
For termination, if it's for misconduct, then it is there has to be a show cause or email, a written notice for show cause lah. So yeah, so if you're talking about termination on grounds of misconduct, then yes, it is important that it's not mandatory, but then it is necessary that the employer gives a letter of warning, and also ask for a show cause of what has happened. But if you are talking about just retrenchment in terms of termination by retrenchment, termination because of retrenchment or redundancy and all, that one does not require a warning, written warning or email or letter. So, but prior to that, there has to be consultations by the employer, as a good practice, consultation with the employer, the employee, to state, what is the position of the company, what are the finances like, have a town hall, discuss on what possible solutions can be done, because retrenchment should be the last option. You see, so so there has to be a constant discussion and clear two-way communication if it's a termination for the redundancy. So, but if it's a misconduct, then so it has to be written. There has to be a warning lah.
All right, thank you very much, Mike. Our time is up. It's 1 o'clock, so we are ending our session now. We will have our 10th session next week on Tuesday, 30th of June, Same time, 12 p.m., we will be discussing about the money laundering cases that have been on the medias and the news recently. We will discuss about the law and the cases. So stay tuned and join us next Tuesday. Bye-bye.
Bye.